President. Have a seat. All right, everybody. This is the 10-second warning. So streaming meetings has really changed the nature of what we do, because now I feel I have to be attentive to all the audiences that are present. So I'm Tom Rogers. I'm the superintendent here. I want to thank everyone for coming tonight. For those of you who shared questions in advance, just tell you a little bit of the order of business for this evening. I'm joined by Tom Letty from the firm of Ingerman Smith. They are the school district's counsel, and Chris Powers, also from Ingerman Smith. And tonight's conversation is going to be about school discipline. As I think everyone is aware, the school is engaged in some disciplinary matters right now, and because Mr. Powers is the attorney of record in those instances, we're going to have a conversation where he's going to talk only about generalities, because we're bound by FERPA, which is the Federal Education Privacy Act, so we can't talk about any student discipline issues. Anything that he or I say tonight is not related to a current disciplinary issue. These will all be about process and how the system works. But I felt that it would be useful for the community to have an education on how school discipline works. And Chris agreed to make some time available in his schedule, gave us an evening, so we appreciate that, Chris. So the way this will go is Chris is going to do a presentation. When he reaches the end of his presentation, I'll take the questions that were asked online. I'll ask them of Chris on behalf of the people who wrote in. And what I would just ask the audience to do is please refrain from shouting out, because again, we're trying to protect the district from liability because we are engaged in these matters right now. So with that as a preference, I will just introduce Chris by saying prior to working in Syosset, this is my 10th year. I worked 5 years at Nassau-Bossi's. The firm of Ingerman Smith also represented that organization, so I've known Mr. Powers for more than 15 years. He is a former prosecutor, and he brings a wealth of knowledge from his time in law enforcement to this work, and a wealth of experience because the firm represents close to 60 school districts in Nassau, Suffolk, and Westchester, and so we are not alone in being represented by this firm, and Chris has the experience of working across multiple jurisdictions and advising us on what the norms are and what the appropriate processes are across all those jurisdictions. So without further ado, Chris, thank you very much.
Great, thank you, Tom. Good evening. So thank you for inviting us tonight. I'm here with Tom Letty. We do represent a lot of school districts in Nassau, Suffolk, Westchester, and upstate as well. We are in schools on a regular basis. As of this morning at 10 a.m., I've been in 4 school districts this week alone. So we're in the districts. We have a kind of a good feel for what's going on in districts, the latest issues that are confronting school districts as well. And we do what we can, both legally and practically, to give some pointers to school districts in terms of what are the biggest issues going on right now and how can you address those issues. 25 years ago, when I first started practicing in education law, I had a very experienced superintendent of schools. She was a superintendent of Longwood, Candy Swenson, and she pulled me aside and said, you know, Chris, when you have 8,000 students, it's a big district, 8,000 students and 1,000 staff members coming onto your property 10 months out of the year, you're going to have issues. No true words are ever spoken. You do have issues with that mass of humanity coming together for 10 out of 12 months. So how do you address those issues? Here in the Syosset School District, you have a code. It's a code of conduct, it's a code of discipline, and it's a code of support as well. Most of my districts just call it a code of conduct. You go so much farther beyond just a mere code of conduct because you do provide support to students as well. So in terms of the rules and the regulations that are applicable here, I've gone through your code of conduct, and I think when it first started back in about 2000, it was 24, 25 pages. Now it's 53 pages. And it kind of lays out exactly who does what, who has what responsibilities. And it's quite broad. It goes into what is expected, what is demanded of students, parents, staff members, across the board. It's a very comprehensive document. We turn to it for our guidance. In terms of discipline, you're going to hear 2 main things from me tonight. First, the code of conduct really guides what we do. And I keep this with me in every Syosset case I have, and I have a number of them going on right now. The other thing that I always carry with me is the education law, because 3214 of the education law, and I literally carry the book with me. It's kind of strange, but I do. So I carry 3214 with me. I refer to it all the time, and it lays out the responsibilities that we have as a school district. What Tom and I have done is we've broken down for you. Just go to the next screen, Tom. Here are 10 major points that we see in your code of conduct. Your code of conduct is board policy 5300, and we've been able to go to page 13 through 16 and come up with the heavy hitters that we see on a regular basis. These are things that students are required to do. These are things they had to avoid doing as well. They cannot be disruptive. They cannot bully other students. They cannot obviously engage in any kind of misconduct with pornography or technology or things like that. So it kind of lays out in your code of conduct the general things that kids are allowed to do and not allowed to do as well. Next screen, Tom. So under your code of conduct, you have a general provision, which is disorderly conduct, violent conduct. You're not permitted to do any of this. And the word that you're going to hear a lot in the presentation is this concept of progressive discipline. Progressive discipline means the following. If you do something the first time, you get sanctioned here. If it happens again, it's going up. It does not mean the following. If you bring a knife to school, for example, unfortunately I have not had that here, but if you bring a knife to school, it doesn't mean we start at a verbal warning, hey, don't do that again. We jump immediately to the more severe sanction, which would be a superintendent's hearing and a suspension potentially for a long-term basis. So the general provisions are in 5300. So we cannot take you out of the classroom unless there's due process. So what is that due process? How does it work? The level of due process increases as the sanction increases. So if a student is running down the hallway and a staff member, a teacher says, slow down, there's no real required due process other than slow down, you were running. That's the end of it, that's the extent of the due process. However, when you start getting into serious matters, weapons possession, drug possession, that sort of thing, when you're potentially going to be suspended for an extended period of time, you as a student and the parents of students, you have certain rights. We're going to get into that under 3214 of the education law. So transportation, we are required to get kids to school every day, but if a kid is acting up on a bus and the bus driver makes a report of that to the director of transportation, then to the principal, principals can meet with the parents and say, your son, your daughter has not been behaving on the school bus. As a result, they're not going to be able to ride on the bus for a week or two. It does not require that there be any kind of a full investigatory hearing into that process at all, but rather the parent meets with the principal. They go over exactly why your son's not going to be allowed to take the bus for a week or two, and that's the end of the process when it comes to transportation. A similar analysis when it comes to things like extracurricular activities, athletics. So if you are on a particular sports team and you engage in certain behavior and the coaches catches wind of that and the principal catches wind of that, they can actually say, you're on the football team, you're on the soccer team, you're not going to be able to be on that team for a while because of something that you did. It does not require a hearing. It doesn't go to the superintendent of schools. It doesn't have attorneys present for any kind of fact-finding or any kind of like sworn testimony in terms of that procedure itself. So as you climb the level of potential sanctions, the due process is going to increase. We're going to show you that in a minute. So if something occurs in school that merits an in-school suspension, that is not covered by the education law 3214, but it is covered by your code of conduct. And what has to happen is that if a student commits an act that does not rise to the level of an out-of-school suspension in OSS, they can be suspended in school, what's called an ISS here in the Syosset School District. The principal can impose that sanction, an assistant principal can impose that sanction as well, that ISS. Again, there's no formal process where you are allowed to come in to have written notice of the charges and that there's a hearing. That does not happen for ISSs because it's not as severe as what's about to happen with an out-of-school suspension. Okay, suspensions of 5 days or less. This is commonly referred to in education settings as a principal suspension. Most of the cases I do here are with the high school students, so I deal with Dr. Durante. So what happens is that if an event takes place, Dr. Durante will look into it. He will assign one of his APs or other staff members to do an investigation into the event that occurred. If he deems it appropriate, he has the authority to suspend a student for up to 5 days. That's driven by the education law 3214. That's driven by your code of conduct as well. That is the maximum authority that the principal of the high school has. It's a maximum authority that the principal of any public school in the entire state has, which is a 5-day out-of-school suspension limit. That is the most that they can impose. So the way it works is that The principal, with the assistant principals and with other staff members, looks into a matter, and what Dr. Durante does, he'll generally run some of these things by Dr. Rogers, knowing that there's some kind of a suspension that's going to be imposed on an OSS basis for a principal suspension of up to 5 days. So what happens with an out-of-school suspension? A letter is generated from the principal's office. It says, "Hi, I'm the principal. Mom and Dad, your son or daughter committed the following act. I have reason to believe they committed this act. Let's call it something as simple as vaping in a bathroom." And I'm not even going to get into THC, just vaping in the bathroom. So as a result of their vaping in the bathroom on Wednesday, November 15th, 2023, your son or daughter is going to be suspended. You had the right to come in for something called an informal conference. An informal conference is mom and dad come in, they can have their student, their child with them. They come in and they have a discussion with the principal of the building. In that discussion, and it's truly called an informal conference, the principal can explain to mom and dad what happened. Mom and dad have the right to ask questions of the complaining witness as the events that happen on that particular day. So the principal actually sets the parameters for the out-of-school suspension informal conference. So when mom and dad come in, the principal would say, "Mom and Dad, you have the right to ask questions of the assistant principal. He or she is right here. Ask them what you like concerning the events that occurred on this day. I will also afford you, Mom and Dad, the opportunity to tell me your son or daughter's version of the facts." The principal at that point almost sits as the judge over the case now, having heard both versions, and he or she, as principal, has the authority to suspend a kid for up to 5 days. The suspending authority of 5 days or less, that's driven by the educational and by your code of conduct. Now, what notice is required to be given to the parents? These things move quickly. So if an event occurs on a Monday, let's say it's a kid caught vaping in the bathroom at 10 o'clock on a Monday morning. That investigation will likely be concluded that day. A letter goes out either that day or the next day to mom and dad saying, "Come on in for your informal conference if you want one. Come on in to ask any questions of the complaining witness as well." And the decisions are generally made within a couple of days, and the suspension can be imposed up to 5 days. So what do we do about the charges? We provide it to mom and dad. We give them notice early on, because they're going to notice, why is my son or daughter at home here? Well, there's been a suspension that's been imposed upon him or her, so come on in for the informal conference so we can discuss it. The informal conference with the principal sets the game rules, the parameters for the discussion, and it truly is a discussion. I've had cases where mom and dad will show up with their attorney. Attorneys are not allowed to attend informal conferences. And if an attorney shows up for an informal conference, the district calls me, I speak to counsel, and then there have been times I had to come to the district and say, "Counsel, you and I are going to sit outside. They're going to have their informal conference," because it truly is informal. As soon as the guys in the suits come in, it becomes a formal conference. We do not allow that to happen. So what happens in the event that a principal, let's call it the superintendent, catches wind of an appeal? So the principal puts a kid out for a student out for 5 days. The parents had the ability to appeal to the superintendent of schools. The superintendent has the authority to look at the matter itself and to make a decision as to whether he's going to uphold or overturn the suspension that's been imposed by the principal of the building. Thereafter, if the parent is not satisfied with the superintendent's decision on the appeal, they can climb the ladder and go to the Board of Education for the Board of Education to weigh in on whether or not the appeal should be granted or the appeal should be overturned. Then finally, we have, in the event that mom and dad are not satisfied with what the Board of Education has had to say, what happens next is they can go to the Commissioner of Education on an appeal. That appeal must be taken within 30 days. Those appeals to the commissioner are all done on papers. They go up to Albany. The commissioner has attorneys that work in her office, and the commissioner then ultimately makes a decision on that matter. So you have to climb the ladder from principal, the superintendent, to Board of Education, to the Commissioner of Education. Okay, so for the more serious matters, and I'll give you examples. Possession of a knife, drugs in school are very serious as well, any kind of like sexual touchings. Really serious matters wind up going to something called a superintendent's hearing. I have now done over 2,000 superintendent's hearings. They happen. And the way we deal with them here in Syosset is the letter goes home to mom and dad, ask them to come in for a hearing. These things also happen very, very quickly because the timeline is that you must have the superintendent's hearing within 5 days of the suspension. So if an event takes place on a Monday, let's call it a fist fight between two boys on a Monday, you will be doing testimony on that case on Friday. That's how quickly these things move. So the way it would work is that if there's a fist fight at the high school on a Monday morning, the investigation is done. Letter goes out from the principal, which is his 5-day authority. The 5 days says you're out for 5 days, you have the right to an informal conference. Concurrently, paperwork is generated. It's sent to the superintendent's office. Dr. Rogers takes a look at it and says, okay, we need to increase the sanction potentially. Let's set it up for a superintendent's hearing. The paperwork then comes to me in my office in Hauppauge. I take a look at it. I oftentimes am in touch with the building itself, get all the facts down. We generate the charges. And the charges will say, on Monday, the 13th of November, your son engaged in a physical altercation with another student. That's what the charges say for a typical fist fight. Then what will happen is the letter gets served upon the parents. If the event occurs on a Monday, the paperwork will likely be generated and out to the parents by late Tuesday or early Wednesday. So we drop everything to get into these hearings. The hearing is then set up for a Friday. What you do here in Syosset is, this is a pretty big district. I think you have 6,500 students. Dr. Rogers can't preside over these hearings, so he designates a hearing officer to serve as the person that will listen to the evidence in the case. So what Dr. Rogers does is he appoints a hearing officer, sit in his stead, which is, Mr. Hearing Officer, Madam Hearing Officer, you serve as basically the judge over the case. You listen to the evidence in the case, and then you thereupon generate a report to me concerning findings of guilt or innocence, and what's the recommended sanction to be imposed. That process usually takes days to put together, but we must be ready to go within 5 days. Why? Because if you don't do it within 5 days, on day 6, the student has the authority to come back to school. So we always scramble to get these things done. You have precision here where we've never lost a case because of timeliness. It always happens where the paperwork comes to me, I'm able to get the hearing officer. We also bring in court stenographers to do the work as well to take down the record, and the record is then developed. So you move quickly here, and it does work. It works very well. Your principals are on top of it, and Tom's office is on top of it as well. So we then do the hearings, and as a matter of practice, we always sit down with parents ahead of time before we do anything formal on the record. Frankly, that's not required by law, but I think it's the right thing to do. So I will sit with the principal next to me, we'll meet mom and dad, and it's pretty emotional because the parents come in, they realize their son or daughter has potentially done something really serious, and we sit down, and there's a certain conciliatory feature to it where it's like, Mom and Dad, here's the process. And we always afford to parents 3 options at the superintendent's hearing. I just did one this morning in another district. Option 1, you can do the following. You can go to a hearing. What is a superintendent's hearing? It's an administrative proceeding wherein I call witnesses. It's usually the principal or the AP to serve as a witness. I ask them questions. That's called a direct examination. Who are you? By whom are you employed? What are your duties and responsibilities? I direct your attention to Monday morning. Were you working? Did you do an investigation? What did you come to learn? Did you see injuries on a student? Did you look at the videos? We run through in a Q&A exactly what happened from the event that occurred on that Monday morning. The parents also had the right to ask questions. That's called the cross-examination. They also had the right to retain counsel. So we always present to mom and dad before we do anything formal on the record 3 options. Number 1, do the hearing. And what the hearing will result in is a finding of guilt or innocence of the charge, number 1, and number 2, what's the appropriate sanction to be imposed. A report is then generated by the hearing officer. It goes to Dr. Rogers. Dr. Rogers then can say, I accept, reject, or modify what the hearing officer has recommended to me. The track record here is that Dr. Rogers uses hearing officers that he trusts their judgment. So generally what the hearing officers recommend, Dr. Rogers adopts. So option 1 that we present to parents is do the hearing itself, leave the fate of the matter in the hands of the hearing officer and ultimately the superintendent of schools. Option number 2 that we always present to parents is the following, which is you can also adjourn the proceedings today to secure counsel, to speak to an advocate, to speak to family, whatever time you need, not a problem. We'll consent to the adjournment with the understanding that your son or daughter remains on suspension until we reconvene. Whether that's 2 days or 2 weeks, the kid stays out during that time. The third option that we always present to parents, and where the vast majority go, is something called a no contest plea, where we express to the parents we need not have the full factual recitation on the record of the events that occurred, but rather if you say we're not contesting the charge, we then agree upon what the sanction's going to be. What you do here in Syosset, frankly, I think it's the right thing to do, it's an effective thing to do, is Dr. Rogers will often set parameters for the suspension. He'll give a long date and a short date. So if you have a student that's involved with some kind of a drug incident, vaping THC in the bathroom, you could just put them out for months and months and months and give it a long date. Say, and we'll see you in 4 months. Goodbye, good luck, we'll educate you, and we'll see you 4 days and 1 month from now. He could do that. He doesn't, though. What Dr. Rogers does, and I think it's very effective, he'll say the following: I'm going to give you a long date, let's call it 4 months, just for point of reference. However, if you get the help that you need, if you go into drug counseling, you're actively engaged in drug counseling, you're prepared to stay in drug counseling for the balance of the year, Dr. Rogers has the discretion of allowing the student to get back to school sooner. What does that do? Why is it effective? It puts the student in the middle of the equation. It gives the student the ability to say, I've had an issue, I'm addressing the issue, I can prove to my school district and to the superintendent of schools that I am addressing the issue, and I want to get back to school. We use it as a motivating factor. And I can't tell you how often parents say to us, he or she's not listening to us, but they want to get back in school, they'll do what you ask them to do. So we stand with the parents shoulder to shoulder, which is, let's get the help that your son or daughter needs, and if they do the right thing, Dr. Rogers exercises his discretion and lets the student back sooner. So we set a long date and a short date for that process to run out. So what I have found is that 95% of the cases, the parents avail themselves of that opportunity. We can also send a student out for example, there's an anger issue. If you go for anger management and you're actively engaged in that process and you come back with proof that you're actively engaged, weekly or monthly letters, the superintendent has the authority to roll that sanction back as well, and it's quite effective to do it that way. Okay, so at these superintendent's hearings, mom and dad had the right to counsel. They can also present evidence, and they can ask questions as well. If they call witnesses, their questions are called the direct examination. I get the cross-examination of the witnesses as well. The superintendents do have the authority. Some of our smaller districts, the superintendent actually presides over the matter, but in larger districts, the superintendent brings in a hearing officer. The superintendent can designate a hearing officer to basically designate for him what the appropriate fact-finding is, and then the superintendent has the authority to accept, reject, or modify. Next one, Tom. Okay, you may have heard of something called a burden of proof in a criminal case, which these are not. A burden of proof in a criminal case is beyond a reasonable doubt. The theory being, if you're going to potentially take someone's liberty away from them, you had to have a lot of quality proof. It's got to be way, way up there. It makes sense. Liberty is not an issue here. What's an issue here is suspension. How long will the student potentially be suspended? So our burden of proof in the superintendent's hearing is competent and substantial evidence. So it's a relatively low burden of proof. And the other thing is that hearsay is admissible. It's an administrative proceeding. So you put together the competent and substantial evidence burden of proof, which is relatively low, and the ability to prove the case through hearsay evidence. These generally are not difficult cases to prove. And we say this to parents. If we know what happened here, let's come up with a solution. Let's get your son or daughter the help they need. They're going to have to actually sit out some period of time, because that's all part of it. So you can have a concept of there's an end where a sanction is imposed, let's call it 2 months, but if you get the help you need, we're going to get you back sooner. So you kind of like feed in the ability to work with kids in order to have them cut their sanction to a lesser sanction. Okay, if a student has a prior history, that is only considered if there is a finding of guilt. So we say to parents all the time, in terms of what the appropriate sanction is, it's driven by 2 things. Number 1, the underlying act itself, how bad was it? And number 2, we'll take a look at your son or daughter's prior history. Prior history has one of 2 effects. First, it could have a mitigating effect, which is no priors helps the kid, clearly. If the student had a prior series of disciplinary issues, including suspensions, then the concept of progressive discipline kicks in, and you can clearly see how that would be a complicating factor and would lead to a longer sanction to be imposed. We always make sure the sanctions are proportionate. Now, I get this question all the time. Are there like set times where a student has to be out? This is not like the penal law. In the penal law, if you commit an A1 felony, it's 25 to life. If you commit a C felony, you go to jail for up to 15 years. We don't have that here. So what we do is, on a case-by-case basis, drawing upon the number of cases we've done here and elsewhere, we come up with an idea as, here's what we think is appropriate for this, and we consistently apply that. There is no actual sentence structure, but we make sure it's proportionate and consistent. And you have to be fair, proportionate, and consistent with these matters. We are asked the question oftentimes about something called a permanent, it used to be called an expulsion, a permanent suspension. I've done this for 25 years. I think I've had 2, with serious physical injury, where the student was actually in jail, that sort of thing. kids generally are not out for forever. And the Commissioner of Education and the many we've gone through in the 25 years I've been doing this, they're very much opposed to permanent expulsions, very much opposed to that. So kids generally do not receive permanent expulsions, but there are long-term suspensions that are imposed by school districts, including yours. The superintendent and the Board of Education has the right to let a student back if they voluntarily are participating in outside counseling help. And I think that is absolutely critical. The other thing that we can work with parents on is where we say, okay, your son or daughter seems to be struggling right now. Do you, mom and dad, agree? Do you give us your acquiescence to have a psychiatric examination done? We pay for it, we get the psychiatric examination, we give you, mom and dad, a copy of it, and we do that for this reason. If there's some underlying issue with your son or daughter, we need to address that now. What I say to parents all the time is that your son's in 10th grade. We have another 2.5 years with him. Use the resource of the school district to help you. Let's identify the issue. If there is an issue, let's address it working together. And most parents are accepting of that. They can also get their own psychiatric and share with the school district. It's not something that we can compel. But oftentimes when we suggest it to parents, which is let's get a psychiatric, they are more than willing to do so because they also want to get as much information as possible on their kid. Okay, you're not allowed to say to a kid, you had to go and work at the Red Cross as a condition of return. You're not allowed to do that. But here's how it works. If a student is to be suspended for a month and the parents say, I'm going to have my son go to the Red Cross and to do 45 hours of community service, will you, superintendent, consider that and to have the sentence reduced? Superintendents can always reduce the sentence, always. So if someone wants to get involved with community service, a Red Cross, church, synagogue, mosque, and they are doing certain work and they come back to us saying that, my son or daughter has learned a lesson here, they're doing the right thing, will you consider this? The superintendent can always alter the sanction as a result. Involuntary transfers, we really don't do that. I mean, the only place that would be applicable would be between your two middle schools, but that happens on a very rare basis. But there is a procedure under 3214 of the education law to do that. Next one, Tom. Okay, hearings under the education law, there either has to be an audio tape running or a court stenographer. What they do here in Syosset is that they actually have a court stenographer come in. We had one here yesterday. She takes down everything that we say. It kind of lends towards the formality of the process. This is no longer a discussion in an office. This is a large conference room. There's a guy that looks like a judge who's sitting there as the hearing officer. There's guys in suits, gals in suits. They're all asking questions. Looks very serious. It's a very formal process, and that's part of what we do with the superintendent's hearing. The hearing officer, his or her report is only advisory. So Tom Rogers will then take that report, review it, and make a decision concerning the appropriate sanction to be imposed. The way it works, once a superintendent, let's say the superintendent suspends a student under this process for 45 days, the parents can always appeal to the Board of Education. The Board of Education then must decide the matter on the record that is before them, which would be the transcript, any exhibits that were introduced into evidence, photographs as exhibits that were introduced into evidence. They would sit in executive session and make a decision on the matter and then render that decision as to whether it has been upheld or overturned. In the event that the parents do not agree with what the Board of Education had to say in terms of their decision, the parents can then go to the Commissioner of Education as well. You have to meet those procedural steps before you go to the Commissioner of Education. Off-campus conduct. There are circumstances where things that happen off-campus, we had the ability to do something about it. So if Tom Letty and I are jawing at each other on a Tuesday afternoon at 12 o'clock, and we say, I'll see you at 3, and I'll meet you at, around the corner at a store, and we're going to have a fight, that is deemed to be a sufficient nexus for us to say the beef started at the school, and the mere fact that it was set up at the school and then led to a fight off premises, that's enough to have jurisdiction over the matter to actually impose those sanctions. These are oftentimes fact-specific, so we had to look to what is the nexus to the school district. Where we have things happen is, kids that communicate over a weekend, making threats, I'm going to get you on Monday in school. That also gives us sufficient reason to exercise jurisdiction over it and to suspend students as well. Okay, so we had, and here's just a case from 2007, where a kid decided to put up an instant message with an image of a pistol firing a bullet into a person's head and saying, kill this person who's a staff member. That particular school district suspended the student for an entire semester, went to court, and was upheld as well because it was with reference to a particular staff member. So it can happen that way as well. We get so much computer use issues, we have to make sure we have a sufficient connection to the school district to gain jurisdiction over it. So what happens to kids who are out on suspension in terms of their educational services? If you are of mandatory school age, which is 6 to 16, we have the absolute right under the education law, the absolute responsibility to educate kids. So if a student is 12 years old and is out on suspension for 2 months, it is our responsibility to educate that student. So you do that. Districts do it in a lot of different ways. Some have something called an suspension room, where they have kids after school come and receive their suspension services after school from like 2:30 to 5:30 in the afternoon. You can also send tutors to house, which is we're going to send a teacher. The teacher's going to work with you for 2 or 3 hours a day. We have that responsibility of keeping your studies up. If it's a special ed student who's out on suspension, we also have to provide to him or her their IEP services as well. But we absolutely have the responsibility of educating kids. Now, once a kid hits 17, 18 years old, they're no longer mandatory school age, so superintendents could say, you're out on suspension for 2 months, I'm not going to educate you. Most of my superintendents continue to educate, realizing the student's going to be coming back. We want him or her, upon their return, to be consistent with the cohort. So if the cohort's on Chapter 7, they want their student that's on suspension to come back on Chapter 7 as well. So most superintendents will exercise their discretion, even though they're not required to provide educational service to a 17, 18, or 19-year-old, they'll continue to educate the students. We are required for the young kids, for the K through 6, of educating 2 hours per day, which is 10 hours per week. For the secondary students, which will be middle school here and also high school, it's 15 hours per week. And what they generally do is they focus on 3 hours in math, 3 hours in science, and they break it down that way instead of like 15, 20 minutes of each. So they'll break it down that way. What we have found is that kids actually do pretty well when they're out on suspension in terms of academics, because if your English teacher or an English teacher is sitting next to you, you get a lot of English done. And kids oftentimes come back in good academic standing upon their return from suspension, which is not a bad thing at all. We are required to continue to educate special needs students and provide them their support services as well. It can be quite cumbersome to do so, but it's our responsibility. Okay, so for special ed students, there's a couple of additional protections that are built in. And I'll make it as simple as I can, which is for a regular ed student, a non-special ed student, the process for a superintendent's hearing is actually 2-tier. Number 1, fact-finding. Did the student do it, yes or no? Number 2, if the student did it, what's the appropriate sanction? So it's 2-tier process. For a special ed student, it's actually a 3-tier process, which is, did the student do it, yes or no? And then there's a built-in process called a manifestation determination, which is, for the act that the student was found guilty of, was it a manifestation of the student's disability, yes or no? And if it's a manifestation, meaning almost like it was connected to their disability, far lesser sanctions can be imposed, but other things happen instead. Okay, so what is a manifestation determination? The school district brings in people, staff members that know of the student. Mom and dad can be present as well. They determine who are the folks that know the student in order to make a decision. And the critical questions that have to be asked are right below there. Role of the manifestation team. They have to determine whether the conduct in question was caused by or had a direct and substantial relationship to the student's disability. That's question 1. Or if the conduct in question was a direct result of the district's failure to implement the IEP, basically our fault, we did not implement. If the answer to that question is yes, then what happens is that the student receives special protections, meaning that the sanction is going to be substantially lower, but other things occur. So the mere fact that a kid has something called an ED, an emotional disability, that does not mean that there's an excuse for everything that he or she does. It's the subject of an analysis by the manifestation team. So if it comes back that it is a manifestation, there's a whole process that kicks in, which is there has to be something called a functional behavior assessment. They have to then implement the BIP, the behavior intervention plan, which is let's address the issue to avoid it happening in the future. If it comes back that it's not related to the special needs student's disability, they could be disciplined like any other student as well. Okay. There are circumstances where even if it comes back that it's a manifestation of the student's disability, meaning that it is connected to disability, the superintendent can still suspend that special needs student for a certain amount of time, which is for 45 additional school days, and that would be for the worst offenses. So if you have a special ed student, it's deemed that they did the act. It's also deemed that it's connected to their disability. The superintendent has the authority to continue to suspend a student for up to 45 school days if it's one of these three things. The student caused serious bodily injury, the student possessed a weapon at school or a school function, or it's involving a controlled substance as well. For those circumstances, the superintendent can impose an additional 45 days. So those are the most severe acts that we see in many, many schools, and that's why the superintendent has the authority to do that under the law. Tom? Okay, so what we have is the manifestation team convenes, they make a decision, and in the event that it comes back that it's not a manifestation of the student's disability, we return to the student discipline matter, the superintendent's hearing for the imposition of the sanction, the appropriate sanction to be imposed. Okay, so we actually went to page 22 of your code of conduct. There are 15 different consequences that are listed, and they go in severity from the least severe oral warning all the way down to permanent suspension from school. I said a few minutes ago that I've seen only 1 or 2 of those in 25 years. Let's start with 1 through 14. So where do the schools basically turn over some of their responsibilities to the administration here? When we start to get into numbers 13 and 14, short-term suspensions and long-term suspensions, that's where the principals reach out to Central to alert Dr. Rogers that we have a student that's out on a 5-day OSS, a principal suspension. The superintendent will then speak to the principal, and they will then make an informed decision, and Tom Rogers had to say, okay, I think we need to actually put this into the superintendent's hearing process for possible consideration of 6 days or more. So for the first 1 through about 12 or so, that's really within the province of the principal of the particular building for they to impose those kinds of consequences. And again, from 1 through 14, the amount of due process that's afforded to a kid is driven by the severity of the act that the student was involved with. So it's when we get into number 13 and number 14 that central office oftentimes gets involved in the process. Significantly, at the bottom of this, page 22, it says, in addition to the above consequences, so any of those 1 through 15, the principal or designee may implement restorative practices on a case-by-case basis. That's awesome. That means that you can impose a consequence, a sanction against a student, but also realize, let's see if we can address the issue as well. So if you have 2 boys that have some kind of a running feud, they get into a pretty heavy-duty fight, they're out for a couple of weeks, the last thing we're going to do is say, come back in 3 weeks, goodbye, good luck. What they do here is they sit down with the kids, they have a restorative practice where they try and get to the bottom of the issue so that these kids can peacefully coexist for the balance of their academic career here in Syosset. It's a very effective tool to have. So you do use restorative interventions, but I will say this, they're always in conjunction with sanctions being imposed as well. So we never say to a student, okay, we're going to put you, instead of doing a superintendent's hearing, we're going to be out for a month, do a restorative practice and you're getting back to school tomorrow. That does not happen here. You have the ability to use clear, fair, and timely consequences with students. You do so on a consistent basis. My experience here is that you have very solid leadership. The principals, central administration, you have a code of conduct that's quite clear. You also have the guidance of 3214. You are consistent with the sanctions that you impose upon students. It's done in an orderly fashion, and most importantly, it's fair, it's consistent, and we want kids back in school if we can have them back in school once they have gone through the process, they've served the appropriate sanction, and they have now learned from their mistake. Okay, we can work with kids on a regular basis. The board has the authority to let a student back earlier if they do the right thing. Tom does that with services through counseling. Tom does that through students receiving drug counseling, anger management, things like that. Once they're informed, the superintendent can actually consider that as a form of, now do I think that the student has learned his or her lesson, can I let them back to school less than the maximum sentence I had imposed. Free speech. The First Amendment of the United States Constitution and the New York State Constitution, that applies here. Students do have free speech rights, but it's not absolute. Clearly not absolute. But rather, there are distinctions to be made. You have a code of conduct as well that goes into issues concerning freedom of speech. You have responsibilities as students. There are certain things you can and cannot say, and I can cite you to pages 3 and 44 of your code of conduct as well. There are all different kinds of speech: free speech, hate speech, and disruptive speech. Hate speech is never permitted here. If it's disruptive and it's causing some kind of disruption in the school, we can also step in and do something about that as well. Okay, what does your code of conduct say about speech issues? Pages 12, 13, 14, and 15 say the following. You can't have a kid using language or gestures that are profane, lewd, vulgar, or abusive. They cannot have disruptive conduct. They can't threaten to use weapons. You come in, you threaten to use a weapon, you're going to be suspended. You're probably going to be out for a long time as well. And when we have kids that come in and they are threatening to do something to the school, we've had consistent law enforcement contact here. The 2nd Precinct has been absolutely great to work with. So we are always concerned about if a kid has made a threat, we get it into the hands of law enforcement to afford them the opportunity to intervene if they deem it appropriate to do so. Students are not allowed to disrupt the educative process. They can't use vulgar, obscene, or discriminatory language. They cannot promote drug use. Those are all no-goes here on school grounds. In general terms, these are other things outside of school you're not allowed to do. Free speech is not promoting imminent lawless action, child pornography, emotional distress, libel-sundry. Those are things that are generally things that have been addressed by the United States Supreme Court. But we're different here. This is a school setting. Kids do have rights, but it's not absolute. So what about the Tinker case? Very important case where all the way down about the 5th bullet point. The court said students not shed their constitutional rights to freedom of speech or expression at the schoolhouse gates, but they want to describe, there is a concept of substantial disruption. That's also part of the Tinker case, where we can step in if it's causing a substantial disruption at school. That is a standard that we apply on a regular basis here and in the other school districts that we represent as well. So there's something here in Syosset where you actually use your website for a source by which community organizations can get the word out that they're having a meeting of some sort. And then there are 11 bullet points as to if you do the following things, you're not going to be able to use our resources to promote. So if you're using something that contains, let's say all the way down the bottom, it's a fundraiser of some sort. If that's the reason why you're using our website, you're using our ability to communicate, we are not going to allow you to use our resources to get word concerning your event out there to the community. But if you do these other things, and we do not weigh in on, we agree with those people, so we're going to let them do it, and we're going to publish it. We don't agree with these people, so we're not going to let them do it. We do not do that here. As long as they abide by these following rules, the viewpoint neutrality kicks in and will be permitted here in Syosset. Just going back to speech, on the left side and on the right side, these are areas of speech that can be restricted. So we have a series of cases, then we also have your code of conduct. So if a kid walks in, all the way down the bottom right-hand corner there, expressly prohibited in school, a kid can't walk in with a shirt that says, enjoy cocaine. That is where we say to a kid, no, you're gonna have to put another shirt over that, here's a sweatshirt, put it over. You can walk with that outside, you can walk with it on Main Street, but not here because that's disruptive and it promotes drug use as well. So what are we allowed to do here in schools? Most importantly, you must be firm, you must be fair, you must be consistent, and that's what you have been for the 10 years that I've been here. Thanks to Tom and also to your principals and then support staff as well. We want to keep kids in school, but if events take place that cause a disruption here, the Syosset School District steps in, they do something about it. They try and teach kids to learn their lesson from what they have done. They serve a sanction of some sort. We meet with the parents. We work with the parents. We get the parents to assist us and make sure that their son or daughter learns from the experience, and we make sure that they know when they come back to school their academics are going to be in good order and that they've learned their lesson. I've had many superintendents say the following to kids as they're leaving a superintendent's hearing. Young man, young lady, next time I see you is when I'm handing you your diploma and you're going off to college. Those are the success stories. It's when a kid comes back where the superintendent or the attorney for the district knows the person, that's a problem. because we try and give them every opportunity to learn from their misbehavior, to give them the support they need, to give them the help they need, and to get them back into the school building where they belong.
We'll stop there and thank you for taking the time to do that, and give you 10 more seconds to drink as much water as you need.
Sure.
I believe you told me that was 51 slides, and you did it in 52 minutes, so
Thank
that's
you.
very impressive.
Thank you.
So you covered a lot of the questions that were emailed in your presentation, so I'll skip over a lot of those. One thing that you didn't cover is a question about what happens when a student is in trouble with the school district and the law simultaneously. How do those two processes run together?
Sure. So if a student is in family court or in criminal court, they oftentimes retain counsel. Counsel will reach out to me, and counsel oftentimes will say, Chris, I need to adjourn the proceedings because I had to go to Westbury, I had to go to Hempstead, or I had to go to Mineola. They will oftentimes make sure that we hold off on our proceedings because the consequences in family court and criminal court are far greater than you can impose here. So what we do in that case is we'll adjourn the superintendent's hearing. We ask them to get back to us in terms of a disposition in criminal court or in family court. And once they share that information with us, we can reconvene the hearing. We can then consider what happened in family court, and it's up to them to share that information with us. I cannot walk into family court and say, tell me what happened to Sam the student. They won't tell me that, and they shouldn't. But I can walk into criminal court in Hempstead if you have someone that's 18 or 19 and get all kinds of records. It's a different story for the younger crowd. So for someone that's involved with law enforcement, what we oftentimes hear is the attorney or mom and dad will say, I think I better hold off on the superintendent's hearing. Let's call a timeout here. Once that's been addressed, we can reconvene the hearing. And then you, Tom, as a superintendent, can oftentimes consider, well, what happened in criminal court? So if the kid is on probation, they have a probation officer, I think that can factor into your equation as to how you're going to handle the superintendent's hearing. In the meantime, the student remains on suspension.
So there's a recent Supreme Court decision called the Manahoy decision that loosened student free speech rights off campus. So what is the impact of that on student free speech? The case that you cited was from before that, the Manahoy case. So has that changed the analysis in terms of what students put on social media, for example, when they're off campus?
Sure, we look to disruption. Is it causing some kind of a disruption here? You are here trying to educate 6,500 students. If a kid's free speech gets to the point where it's disrupting us, substantially disrupting the process here in Syosset, we can do something about it. That's what it is.
What's the analysis for when the district is advised to call the police about an incident?
So if a matter constitutes a crime and it's serious, we call the second precinct. We afford law enforcement the opportunity to intervene. You can't call the police on everything. So right now, if I were to take Tom Letty's pen and put it in my pocket and steal his pen, that would be petty larceny. I'm not calling the police on that. Because we also had to have some credibility with the police. When we call them, we want them to know we have something serious on our hands. It's some kind of a substantial threat. It's drug use. It could be weapons, things like that. We call them. They've been incredibly responsive here. We will assist them as much as we can. There are certain restrictions, so if the police come to us and say, I'd like to know whether this is a special ed student, I want a copy of his IEP. That's not happening. You'd have to get a subpoena signed by a court for us to give them that information. But they're looking for, let's say there's some kind of a big fight that occurs in the cafeteria and there's video of it. If they want access to that video, we're gonna show it to them because they have a job to do. And we'll cooperate with them. So we have an ongoing line of communication with them where we reach out to them, where an act actually could constitute a criminal act for which they may seek intervention and potentially lock someone up.
So what are the restrictions that the school district operates under in terms of student privacy restrictions? You know, why is it that the school district can't explain more about what's going on to parents?
Sure. In its simplest form, the Family Educational Rights and Privacy Act says the following. Mom and dad, I will talk to you about your student. I can't talk to you about other students. And I get this all the time. It happened earlier today. Well, you know, another kid got the following. I can't talk to you about another kid. So what I say to parents is, in much the same way, mom and dad, I will talk to you about your son or daughter. I never talk to other parents about your son. So we have FERPA that kicks in, Tom, and FERPA says the following. Speak to parents about their particular kid. You're not allowed to disseminate information about other students other than to the parents of that particular student.
So there are two processes by which the district identifies and then deals with misconduct. One is the DASA process, one is the code of conduct. It may be confusing to have these two things and they appear to operate in parallel. Can we parse the difference between the two?
Sure, DAS identifies 11 or 12 things that could constitute a Dignity for All Students Act violation. And there are times where a DAS investigation will start, and the DASA investigator, the DASA coordinator will determine it does not fit into the definitions of DASA. But the mere fact that it does not fit into a definition of DASA doesn't mean that the student who is the offender is free and clear. There are oftentimes other things that the student has done where we could say it's a straight, good old-fashioned pre-DASA violation of the code of conduct where you're bullying someone and we're going to do something about that. I will say this, Tom. You know, I read DASA when it first came out many years ago, and it was like, I've never had to tell a principal or an assistant principal, a kid's being bullied, do something about it. They've always done something about it. DASA makes sure that they do something about it. That's basically what it says. It lays out an entire process for them to address the DASA investigation, but the mere fact that a particular matter does not fit within DASA does not mean it cannot be presented as a code of conduct violation.
Okay, so you went through a little bit the process for which, the three-step process for a student with an IEP who goes through the superintendent's hearing 3214 process. Is the school district without options once a student has an IEP if there's a concern about returning that student to the school environment, or what are the options and how would the school proceed?
Sure, we can put it into a CSC. Many times parents are very willing to get a psychiatric on a student. In the event they're opposed to doing so, we can put it into the CSC process, see if the Committee on Special Education can convince them of how that would help their particular child. If we're concerned about a particular student, we do everything in our power to gain as much information as possible. If we're concerned about, the student presenting some kind of a threat, we do have the ability to reach out to law enforcement to suggest to them we have a real concern here. That's done, with great caution, and oftentimes the psychiatric examination will give us the information that we need to assist the student.
So a question here about what would be the definition of bullying from a legal perspective?
It's actually in your code of conduct. There's a definition, and it's on page 48, all the way down the bottom. Bullying means repeated, unwanted, mean, or aggressive behavior towards another person to show you have power over them or to make them feel bad about themselves. That's the definition in your code of conduct. So if one student is giving another student a hard time, if it's within that definition, they're going to be subject to discipline under your code of conduct.
So this is probably more a question for me, so I'll ask and answer it. Does New York State require the use of restorative practices in schools? And if so, is there evidence to support restorative practices? So the State Education Department has given school districts a number of guidance memos dating back to the 2017, 2018 timeframe, and just recently we got another one in March that is from both the Commissioner of Education and the State Attorney General, outlining what they feel are best practices and also cautioning school districts that if we don't use restorative practices, that we may be in violation of student rights. So it's not, the use of these is not mandatory, but the clear assertion is that if school districts fail to use them, then we'll have exposed ourselves to liability. So it is something we put into place in 2018, and unfortunately, a lot of our work around restorative practices was interrupted by the pandemic. So as a practical consideration, the restorative work happens after the punitive disciplinary work, as you kind of described earlier. Mm-hmm. Then back to you. Are there different consequences under DASA or under the Code of Conduct?
DASA contemplates early intervention so that students, if they're saying certain things, calling someone fat, for example, that the student can be spoken to at a grade level that they can understand as to why they should not be doing that. However, if that persists, and now we start to get into an area where we've spoken to that student, they're not getting it, it could then morph into a violation of the code of conduct as a form of bullying as well. So we use DASA as kind of like the early intervention. Let's inform your son or daughter as to this is wrong, this is why it's wrong, and it has to be specific to the age of the child as well. You speak differently to an 8-year-old than you do to an 18-year-old.
All right. You mentioned in your presentation that sometimes it takes a couple of days to suspend a student. I feel it pains to make sure that the public here knows that it doesn't take a couple of days in Syosset. We do things instantaneously here.
So I'll just go over that again. The process in terms of setting up the hearing takes a couple of days. But if a kid walks in tomorrow morning with a knife, they're going to be suspended tomorrow. And then the hearing itself, tomorrow is what, Thursday, will be set up for the following Wednesday. All that paperwork will be ready to go by Friday. Parents will be served those documents on Friday. But in the meantime, that student is out.
And then you covered all of these questions in your presentations, making my job a little bit harder. So last question. How do we assess that a student is ready to go back into the school environment? What are the kinds of things that educators do in the districts that you work with?
Sure. So we often have a reintroduction meeting where if the kid's coming back on a Tuesday morning at 7:30 in the morning, they're there at the principal's office. And one of the things that we say to students that are coming off a suspension, whether it's 5 days or 5 months, is undoubtedly you're going to be asked, where have you been? So principals and APs will share with the returning student, here are things that I would recommend in terms of how you answer that question, which is I really can't talk about that. So we provide them with a structure so they know that if they're being asked questions by other students, how they should respond to it, their suggested answers. Now let's say a kid's coming back and other kids start to give the recently returned suspended student a hard time. We then say to the recently returned suspended student, come see me, the principal, come see the assistant principals, we will intervene on your behalf. And I've seen that happen. So if a kid comes back to school and other kids start to give him or her a hard time, as long as we have that information, intervention by the administration, by the principal, by the AP, and we take care of it doing it that way.
All right, and then last question of the night.
Sure.
What would happen if a school district did a suspension that was atypical for what you would typically see a school district do?
Mm-hmm. So we'll climb the ladder on an appeal. So if you put a kid out for 2 months, then it went to the Board of Education, the Board of Education sustained that, keeping the student out for 2 months, it goes to the commissioner. If the commissioner disagreed, she would direct that the records relating to this matter be expunged. The Commissioner of Education has traditionally not intervened on matters where discretion of superintendents is used because the commissioner's not down here seeing what happened in the building, being part of the actual hearing itself. So she's usually quite deferential to school districts and does not usually intervene and impose an appropriate sanction from her perspective.
All right. So I'll have the last word of the night and just say that there is a bill moving through the legislature in Albany right now that would change exclusionary discipline for school districts. It would reduce schools' options to use exclusionary discipline. So both houses introduce over 10,000 bills a year, and not many of them become laws. But I understand that this bill is something that has a little bit of momentum, so if it's a topic of interest to you, it's something worth researching. So please join me in thanking Mr. Powers for giving us this evening of his time.
Thanks.
And Mr. Letty for operating the PowerPoint presentation.
He did all this, by the
and
way.
likely putting it all together. So thank you both, and have a great night, everybody.
Thanks so much.